with this interior design studio.
Okay.
And really, this was just like information gathering for me today. And
Okay.
if something like jumped out at me and it's like, yes, I need to know this, or yes, I need to, maybe further research this or understand this. So I specifically, I'm trying to go to where the invite was, but someone was talking about my business name, 1215 Design Studio, and saying that needed to be was it trademarked, I believe?
Yeah.
And I was like, okay, why and how?
All right. Perfect. Are you downtown? I know there's a 12, or there used to be a 1215 wine bar, coffee bar.
Right, that's not me.
Yeah.
Yeah, no, but my 1215 is for my birthday, and I think their 1215 is for their location on Vine.
It is. All right. Very
Yeah.
nice. Okay. All right. Well, let's go through the parts of this that I think are going to be relevant to you. All right. So intellectual property. So I call it your IP IQ. Which is just your intellectual property IQ. And what I've found is that a lot of the stuff that we're going to talk about, Stephanie, is free or very inexpensive to you, where you can protect a lot of things or look kind of buttoned up. A lot of people think IP has to be kind of really expensive, but it doesn't have to be. So I want you to kind of understand sort of the different buckets. You were right, like that 1215 is in the trademark bucket. So just to understand sort of what the different these different categories mean, and then I think what's sort of relevant to your business. So these are the four. You've probably heard of these before, but you've got patents, trademarks, copyright, and trade secrets. We're gonna, I think, just kind of skip the patent part here, except for design patents. So is there anything about your studio or your design style? Do you have kind of like a signature mark? I mean, trademark started with like old blacksmiths that actually would put their mark, a trademark, like a literal mark on a thing. Do you have anything like that for your business, as sort of a logo or a symbol or a kind of a signature piece? Your design?
No, I mean, outside of my logo, I'd say no. I'm also an artist, but I don't think any of that really falls within.
Okay. Okay, that's kind of what I figured, but I didn't want to skip over it. So for patents, most people think of patents as being utility patents. So that's the way something functions. It's like the better mousetrap. It's like a better widget. There is this category called design patents, which is really literally just the way something looks. So, you got the iPhone, you've got the Tesla. There are functional patents on both of these things, but these are just the design patent parts of those. So you can get a patent both on the way something functions, but then also just the way it looks. And it's usually a three-dimensional object, but it can include a user interface. So Google actually has this patented as a design.
That makes sense. Yeah.
Yep. So if you end up having something kind of distinctive that's part of your business, maybe you would look at a design patent, but probably not. I just want you to be aware it's sort of out there. All right, let's talk about what I think you care about the most. So trademarks. So this is kind of the jargony phrase here. Really, a trademark is anything that's an indicator of source. So it tells people where a product comes from. The most common, right, is the name, the brand name, right? So that's definitely here in this trademark bucket. it can be incredibly valuable. So, you know, this one's up to like $80 billion, you know, otherwise it's just like brown sugar water, right? So the brand itself can be incredibly valuable. So this for you, I think, is what we are looking at here.
Yeah, this is kind of leaning in my direction.
Okay. So this first part, I think, could be super relevant to you. And you probably hear my screaming 2-year-old. He's having a bad day.
It's okay. I keep muting because my Roomba is running around in the background. So
Not a problem. So the thing about trademark rights, and a lot of people don't realize this, and people love free, is that trademark protection actually starts the minute you first use the trademark in commerce. So it's their common law rights, but they are real trademark rights. So what is the full name of your business? Is it 1215 or is it 1215 Design Studio?
it's the latter, 1215 Design Studio.
Okay. So are you currently putting the TM or an SM next to that on your website or store?
I am not. No.
Okay, so that is free and 100% correct for you to do that if you want to. So common law trademark rights are real. It is a trademark. That's like a gotcha question I ask a lot of entrepreneurs who have businesses. I'm like, who has a trademark? And the only people that raise their hand are the people with registrations, right? But everybody who's doing business has these potential common law rights if you call it out. So you got to put this TM or SM on there. Is a notice feature that says I claim these common law rights to the extent those are available.
What's the S for the SM again?
Absolutely. So if you want to get real fancy about it, so a lot of people just use TM, and you can use TM no matter what. But technically, this trademark is TM and service mark is SM. So technically, McDonald's is a service mark and the Big Mac is a trademark. And so for your design services, you might technically be an SM, but a lot of people don't know what that means.
Obviously.
and the TM works just fine to satisfy the notice function. Sure, come on in. Oh, Lord. Working from home. So
this recording just needs to be sent to me.
Oh my God, it's amazing. So all right, so for the business, you should be doing that right now, and I would probably just put the TM next to it.
Okay.
For what you do, because of what you do, sometimes there's some concerns about sort of aesthetics, you know, like you're like, I don't really want to put a big like lawyer thing on my design. And so you can put, there's some ways if you want to avoid it where you can just put like at the bottom of something, you can put, you know, 1215 Design Studio is a trademark of kind of who owns the business is fine. We like you to put the notice feature up there, but if it's really aesthetically awful, you can as long as somebody can't be like, oh my gosh, I didn't realize Stephanie thought this was a trademark. Like, then you should be fine. So what does this let you do? All right. So common law rights here are limited to your geographic footprint. So only the scope of where you're doing actual business. So Cincinnati for sure, right? So somebody else comes out with 1215 Design Studio and maybe just 1215 anything that's in your space, you can sue them just based on you having stuck that TM on there, right? So you've got legit rights that you can enforce. Those are only because do you have the one location, Stephanie, or what's your footprint?
Um, so I'm local in Cincinnati, but I travel for, also for design services,
For design purposes?
for design services, I'm sorry.
Okay, so the in kind of an extreme example, let's say you just were in Cincinnati and somebody did this in California. So they've got the exact same name and you'd never been to California. Can you stop that person with your common law rights?
I think so.
No.
No.
Oh, so the common law is pretty limited. So, and even though you're traveling a bit, if it's not really, if it's kind of one-off to visit those things and do those kind of services, the
Mhm.
courts might hold really that your common law only established rights might be Cincinnati and maybe not even crossing over like into northern Kentucky, right? So common law rights are free, so they're great. So take advantage of this, but you should think about the federal registration. So if you get the federal registration for the mark, that means that you immediately have the entire country is what you own. And so if you have plans for sort of US domination with your business, and you're like, I'm not in California yet, but I'm gonna be, and I want to franchise this thing or license this thing, then getting that federal registration can make a ton of sense.
Okay.
And once you get that, then you get the R in a circle that you can use. And hello, other people that joined. So only Stephanie was here like 10 minutes after we started. And so I'm just doing like a private thing for Stephanie. But if the rest of you, Ethel or Tiara, and let me see if I can let everybody I'm gonna let everybody allowed to talk. If you all have questions, just because there's so few people here, then I'm happy to just address all those just very specifically while you got a captive audience. So Stephanie has a design studio called 1215 Design Studio. And so we kind of buzzed through the patent part of this, which is not really relevant to her. And we're really focused on the trademark piece right now. So I think you might have hopped in, but trademark is anything that can be branding. So anything that tells people what the business is, where it comes from. And that's most commonly the name of the company.
Okay. And so my name is Tiara, and I'm in wellness, basically. And so I'm not sure if trademark would be I don't know, that seemed like the thing that could be beneficial for me. Just only because my name, I haven't seen many people with my name, and my goal with my business is not to have a gym, but to do events, like wellness events.
Okay, terrific. And is your brand T Fit that I'm kind of seeing as your?
Yep, T-Fit Wellness.
Okay, I love it. So one of the key takeaways that we were just talking about with Stephanie is that trademark rights, and a lot of people don't realize this, are based on use. So you have common law rights just based on using your mark, which you clearly are. I'm seeing it on the screen, and you can and should put the TM. Here, let me just go back so you can see that. You can and should put the TM or the SM next to your brand right now. And that means I claim my common law rights in that mark. So if you're using T-Fit out there right now, in any capacity, you can and should put the TM. And the distinction there is you can just use TM. You don't have to get fancy with the SM. But if you want to be real technical, like McDonald's is an SM and the Big Mac is a TM. So if you're doing services, Tiara, you're technically probably an SM, but the TM works just fine to say, I claim these common law rights in this thing.
Okay. So I guess with that then, I use my T-Fit. That's kind of like my website. I kind of use that more so than T-Fit. Granted, that's my logo that I have. So I don't know if maybe that's something on both ends I can use, because usually people, because I use My T Fit so much
Mhm.
that they're like, oh, you're My T Fit. And I'm like, no, it's T Fit. So I'm like, I don't know if I'm able to do that for both things, because again, it's something that's unique to my business. And that's what usually people like, that's my social media, that's my website. So
Absolutely.
yeah.
Absolutely. So we're gonna do some audience participation here. So anything can be a trademark that tells people where something comes from. In this image right now, if everybody can see it, tell me all the trademarks in here.
I'd say the Coca-Cola, the Enjoy Coca-Cola.
That's right. So Coca-Cola itself, right, is the brand name, and then slogans. So enjoy, right? That is absolutely tells people that's an indicator of source, and you can get slogans separate from the main word. What else in here?
Say the color and the Coke bottle, not the color, the
The color. No, the color. The color.
I was gonna say the color of the round circle in the Coke
Yes.
bottle.
So Coca-Cola is and I think got this particular red associated with soft drinks and beverages. So absolutely a color. Have you seen that Pink Panther insulation that's out there for houses?
Yeah.
By Owens Corning. They
Yeah.
own Pink for home insulation. So absolutely a color. What else? Somebody said it.
I said the Coke bottle as well.
The Coke bottle, right? So as a logo, and even the Coke bottle itself, actually, there's some things that have could be a design patent, so it had a design patent, but also that image can carry on as a brand in itself. When you see that bottle shape, you know that is a Coca-Cola bottle. So yep. So there's one more.
And then maybe the ice or the water.
That's a good guess. I don't know about that. I know they do a whole bunch of like kind of polar bear things. So
Yeah.
so maybe, but that probably not. And I'll just tell you, because I'm being a little tricky, because you already said Coca-Cola, but it's the script. So they can own the actual font of
Oh.
so so usually the broadest way to file for a trademark on the name is what we call a word mark. So we'd submit it in all capital letters, and we'd say, we want to own this mark no matter what style, color, font it ever shows up in, which is terrific because, as you all know, those things change organically anyway. You're like, could be seasonal. It could just need a refresh. You don't want to have to go back and refile like a federal trademark, every time you do that. So most of my entrepreneurs, we file for the word mark and get that registered. You can also register what we call a stylized or design mark, where you actually bake in the style in your registration. And Coke might do that, because if you wrote Pepsi in the same script, especially if it was red, people would probably still think it's Coke. And so having, protection on that and owning that font actually has value to a company like them. So just in this one image, there's like 27 different trademark types. So all of those are in play. And so that, to your question, is a long answer, Tiara, that you have a whole bunch of these that are trademarks that are available, right? It could be the me tea, especially if, and we'll talk about this in a minute, if there's a play on mighty, I don't know if you're leaning into that like mighty fit.
Yeah. It is.
Perfect. So I'm going to use that as an example in a second, but you could have both T-Fit and then my T-Fit. And then I'm looking at kind of the logo, the slogan, all those things are potentially trademarks for your brand.
And so Vance, you said slogans as well.
Correct.
Okay, all right.
Yep, absolutely. And so, you know, the common law rights are great, they're free, so do the free stuff. So, you know, Tiara, you should, I'm looking at that logo right now, the T-Fit Wellness in the lower right-hand corner. If you just plopped a little TM on there, that'd be 100% correct. That would mean I claim my common law rights to the extent those are available in my geographic footprint. So these common law rights are free, but you kind of get what you pay for. It's only going to be in kind of where you're actually doing business.
Okay. How do you, I guess, do that? Because, you know, like some people have like the copyright symbol and you can like do it on your keyboard. Because
Yeah.
a lot of what I do is like digital.
Yeah.
And so I don't know. I guess you could just put TM and make it like really small somewhere.
There's no, it serves the notice feature just to say, hey, you know, so somebody can't pretend they're like, I didn't realize that Tiara thought that was a trademark. And so there's no exact kind of bright line rule for font or size. But when you start, you'll see, you'll see this everywhere. Like you can kind of see it's generally pretty small, both capital letters, usually in the lower kind of right side, and just plop it on there. It can be up in the upper right, like, or, you know, it can be in a place that maybe is not aesthetically that offensive, just as long as it's on there somewhere.
Okay, awesome.
Okay.
That makes sense.
All right, and then so for the federal registration, right, is which is great and can be worth doing, is what gives you all of the United States. So you can file for a federal trademark application. If you get that registration, then you own the entire country. Doesn't matter where you're you could have one small boutique in Cincinnati, and you still own this thing for the entire country. So if as a business, you're like, listen, I'm very content to be in Cincinnati. You know, filing a trademark with the search and the filing fees usually with us, it's like $1,500 to $2,000 to kind of get this federal registration going. It's sort of a, you know, if you're gonna plan for nationwide or global domination at some point, like you want to license and franchise and build a thing, that then getting this trademark process started early is well worth it. If you're like, I love my one shop, you know, we're doing great, you know, I'm not going to expand into Arizona, then maybe just these common law rights are fine.
Vance, I have a question.
Please.
Is that, so it sounds like both Tiara and myself are service-based businesses.
Yes.
So does that federal registration still like work, I guess?
Absolutely.
Or am I thinking too?
Yep. And so despite this sort of kind of TMSM common law thing, everybody gets the R when they get it registered, right? So everybody, once you get the federal registration, you get to put that R in a circle next to it, whether you're a service or a physical product. And we'll get to a little bit more of that in just a second. I think it'll be even more clear.
Okay.
All right, so there's to have something be trademarkable. And Ethel, I see you here. Do you have anything specifically that you want me to talk about? I'm gonna assume no. I'm just gonna keep going. All right, so there's two tests to have something be protectable as a trademark. The first is that it has to be what we call distinctive enough to function as a trademark. So I think this is pretty intuitive to people, but you know, I can't trademark law firm for my law firm, right? If you try to own something that is just what we call generic or merely descriptive, what else is everybody going to call their business? So for you, Stephanie, if you were just design studio, right? Should you be able to get a trademark on that?
Probably not.
No, right? So everybody else would be in a tough spot. if they couldn't call their whatever they did design studio. And so there's this spectrum, this range of these marks where if you're generic or what we call merely descriptive, so the bottom two, usually those are not protectable as a trademark, either with the common law or with a federal registration. So you'll actually get rejected by the trademark office. I try to submit law firm to them, and they'll be like, you know, if it's for law services, they'll say, nope, this is generic or merely descriptive, and you can't get your trademark. So where we really like to see marks that start is at the suggestive level. So that and above, up and to the right, is going to be something that's protectable as a trademark. And what suggestive means is so I'll go my T-Fit Tierra is a perfect example of a suggestive mark. It's where there's kind of a double meaning in it. It's your T, you know, I think that's your nickname, is my T wellness, but then also it's sort of this my T, like mighty fit, and it's got kind of that double meaning to it. I'm not sure how accurate that is, but that type of analysis would be a suggestive mark.
Okay, so would that hold up, I guess, and that because, so my name is Tiara, and usually like my nickname is T. People call me T
Yep.
for short.
Yep.
And so how I spell it, it's a play on words,
Mhm.
you know, because I did a lot of different languages, learned a lot of different languages, and I sounds like E in most languages. So that's the wording of it, or why I spelled that way. But yeah, like it's my mighty fit, but it's my T fit to kind of say, hey, this is, you know, this is for you. It's your thing. Like it's your journey pretty much. So that way, would that hold up, I guess, if I wanted to trademark it, or would that kind of be like, you need something stronger?
Yeah. So that I think is squarely in the suggestive category.
Mhm.
And what's totally fine too, and this applies to both of you, is to have the first part be what we call distinctive enough, and you can still attach something descriptive to the end, right? So wellness here is just generic, design studio is generic, but as long as you have like a hook, you have part of it is distinctive enough, then the whole thing's going to be okay, right? So if your mighty, which I think is very suggestive, has that double meaning, and then wellness, that's all going to be okay, even though wellness is generic, because that the first part's going to carry the water basically for it. And same with you, we'll talk about 1215, but the design studio part, it's okay that you have those descriptive terms in there as long as there's a part that's stronger.
So quick question for you. So with I guess like T-Fit Wellness, that's what I have. That's my LLC. Like that's what I have registered with the state of Ohio.
Yep.
I guess that one would be kind of generic because I mean, I've seen businesses out there say T-Fit, right? And it's just a regular T, or it's something like that, but they're not necessarily spelling it the way I am. So would that hold up as a whole, or you think I would be more, I guess, successful going with the my T-Fit?
Great question. So for the T-Fit, I think what you're concerned about is actually this next test we're going to get to. It's not descriptive, right? So the T-Fit, the T, like if I see something that says T-Fit, that doesn't like mean something in the industry, right? That's not like saying workout gym or wellness spa, right? Like T doesn't have a meaning in the industry. So I think when you do the mighty fit, I think it's got this suggestive double entendre. But in the other two categories that are really strong, is arbitrary, which is where you're using a term that's a real term, but you're using it in a way that is not connected to what it might normally be connected with, right? So, and I think both of you here, that T plus the wellness and the fit, like that's kind of an arbitrary addition, right? There's no reason for it to be T that's related to fitness. You just like, that's part of your name, you connected it. I think that works 1215, it's not like there's something about 1215 in design studios, right? That's kind of an arbitrary number. It's your birthday, right? But that's an arbitrary number from a trademark standpoint that you attached to it. So I think that becomes a really distinctive mark.
Hmm.
And then, you can just totally make up a word, right? So like Exxon and Xerox and Kodak. So Tiara, I think on this threshold, both of your options are perfectly fine, and you may have both or end up just leaning into the one that you think is better.
Okay, I appreciate it.
So
All
you
right,
can-
please.
you can have, I'm sorry, Vince, you can.
Oh, no.
You can have multiple, like you could be, if you go back to that last slide, like, could you be descriptive and suggestive, or is it just one, you know what I mean? Like, is it just one?
So great. So different parts of the mark, right, may have different categories. So to use yours, 1215 design studio. The 1215, my first question would be, all right, where did that come from? And if you're like, oh, 1215 is the code for every design studio, I'm just making this up, like where that's, I'd be like, well, maybe that is too descriptive, but it's your birthday, right? So it's that part is totally arbitrary, random, which makes it strong.
Okay.
And then the design studio part is probably generic here, but as long as you have one thing in the name that is kind of above the line, then you're fine.
Okay, that makes sense.
Yeah. So I'm Ulmer and Byrne law firm. The law firm is what? That portion.
That's generic.
That's right. Yep. So, but the Ulmer and Byrne part is
Mhm.
what?
Arbitrary.
Probably arbitrary. Yeah. So let's do example here. So this is for SCORE, the organization. So we got a slogan here. So our slogan's a trademark.
Was that a question? Did you say?
It is a question. Who's brave?
You said
Yeah.
it's the
Yeah. Yep. So
Mhm.
this slogan could be, if it meets this first threshold. So for the life of your business, where would we rate this on the spectrum?
You go back to that section. Okay.
For the life of your business.
descriptive, maybe.
Okay, why would it be descriptive?
Because I guess implying that, saying your business. I guess it's explaining what SCORE is, I guess.
Oh, okay.
Maybe. I don't know, maybe because I know what SCORE is, so it's kind
I'm-
of like
Sure.
Oh.
So I think there's an argument that it's suggestive.
Suggestive, I was thinking. Yeah, I kept going back and forth.
So why, Stephanie, could it be arguably suggestive?
Can you go back to the thing?
Of course.
I just keep looking at I think because I think it implies I think the word business implies that it's assisting with business. I don't really know.
Okay. So my take on it was that the use of the word life, I think they're kind of using it to have two meanings here. I think they're saying for the life of your business, meaning like they're going to be with you forever in your business, like for the duration of your business. And I think they're also saying for the life, like for the success of your business, like we're breathing life into your business. So I think they're trying to say in this one slogan that they're going to be a partner with you for as long as you need them, and they're also going to make your business successful.
I didn't think about it like that.
But this is how, at least that would be my argument to the court.
No,
right?
it makes sense. Like, I mean, that makes total sense.
Yeah. So I think with that, and so what happens is there is a back and forth with the trademark office. So when they file this, and it is a registered trademark, so this is what one of these looks like here. There would be a back and forth with the trademark examiner. So if the trademark examiner initially was like, this just looks, like a basic statement, I would have a chance to come back and be like, no, you don't realize how clever this is. And then so hopefully you can get a win. So at least there's kind of that negotiation process. It's not like if you get a no, you're toast. So the other thing I want to mention here, and I think this came up a little bit, was so there are 45 different trademark classes that are out there. And that's the reason that like Delta Airlines, Delta Faucets, and Delta Dental can all coexist. Those are all registered trademarks, right? They're all just in different classes. And so there's no what we call confusion between those marks. And so 1 through 34 of the trademarks is for like physical products. And then 35 through 45 are for services. And so T, I think this was you that kind of brought this up. You might, for your mark, you might fall into multiple classes. It's very common. So let's say you have an actual studio, that could be like maybe like a class 35 service. But then if you're doing educational materials online for wellness, that might be in like a class 42, for example. And so what I suggest to entrepreneurs is do the common law stuff, the free stuff first. If you're going to look at a federal registration, maybe just do one class that's the most relevant. And then, as the thing takes off, or if you get really successful, then we can start like SCORE did. Here, each next to that IC on the side, if you can see that, it's probably tiny. That's a class. So here's International Class 16, and it's printed educational materials. International, so that's a physical product, so you got the actual materials themselves. Class 35 right here, which is a general business class. So you've got business management consulting. You've got, then they've got 36, which is like a financial services, 38, 41, 42, and 45, right? So of the 45 classes, they've got a bunch of them here all in this registration.
So question for you.
Yep.
So when I've done any type of workshop or event or anything like that, I usually call it something different, like and say, T-Fit is the one, putting this together. I guess my question is, because you said I can classify my business as different things. Is that classification, like if I'm doing a workshop, I'm not necessarily calling it like the T-Fit Wellness Workshop, would that still apply? So for example, I did an event called Brunch Fitness, and it was for women and about wellness. And that's what I called it, but my business is the one obviously putting it together. Can I still classify my business as like doing workshops? And does that make sense?
Yeah. No, that's a great question. So it's very common to have sort of a stacked brand. So, we've got SCORE with a slogan here. You might have, T-Fit, and then was it brunch, did you say?
Yep, Brunch Fitness.
So T-Fit, Brunch Fitness, if in the advertisement, it's sort of, T-Fit, Brunch Fitness, then for sure. And then, sometimes it's like Brunch Fitness, and it's like powered by T-Fit, or somewhere on there. It's like shows that there's a T-Fit, service or something. Then like you could say that probably all of those marks are associated with that particular offering or service.
Okay.
So, what we don't want the trademark tail to wag the business dog. like what we usually do is look at what you're already doing and kind of the marks that you're using and look to kind of try to protect what already exists there. I don't want you to like change your business to get another trademark class, right? So it's a kind of thing where usually we take a look and we're like, all right, well, how important is this, brunch fitness? And you're like, well, it's kind of taken off. Where, by the way, would that fall?
So that would be that's an event. So like I said, I'm going in a direction where I'm putting together like workshops and events, and they're not necessarily, it'll be basically the brunch fitness in particular is wellness, basically. It's fitness, food, DJ, it's like a whole thing
Okay.
that I put
mean,
together.
On the trademark spectrum, where would brunch fitness land?
Oh, on the I don't know. I'm thinking either descriptive or suggestive.
So the concern would be that if it's during brunch and it's fitness, that it's merely descriptive and not ownable just by itself.
Right.
So in that situation, we might say, can we add maybe even something else to it that would help it sort of move up the chart a little bit? So that could be even just like tea and brunch, like some kind of play on the tea there with the brunch, to try to make it really clearly move it up into the suggestive. But maybe you've also just got your poor brand on the advertising where you're like, listen, it's tea fit, and this is the brunch wellness offering, and maybe just because they're tied together, it's distinctive enough for you.
Yeah, I was like I said, I was just thinking just with my business kind of where I'm going, because I don't really necessarily want a gym. I don't want a facility. I really want to do, like I said, workshops and things like that. It kind of, when I'm classifying my business, I want to be sure that I'm adding that, because eventually I do want to trademark my business and not just have it in Cincinnati. I want to be able to kind of move outside and have other cities and states kind of adopt the same sort of setup, like almost creating like a model.
Totally. Yep. So just to be clear, do you have a trademark now?
No.
Yes, you do. We just talked about that.
Yes, I do. I mean, yes, I have a common law trademark,
which is a real trademark. So you don't even have to qualify it with common law. You have trademark rights right now. So, when you're talking to people, or if people are interested in a licensing or franchise model, you already have and own that brand. So people don't talk that way. And it's a very common misconception, but now what you're talking about is, yes, at some point we may want to do this federal registration for you sooner than later, and get that. Its whole thing takes about a year to get the federal registration finished, and there's a bunch of benefits to it. If your plan really is to grow and scale out, and let's call it $1,500 to $2,000 is worth kind of owning that, then that's the math.
Okay.
All right. So the last threshold here is the likelihood of confusion. So this is pretty intuitive also. So you got to be distinctive enough, the first threshold. And then if you are, then you also can't be confusingly similar to somebody else who's out there. And so Stephanie and I were talking about, hers is 1215 Design Studio. Stephanie, do you have a problem here with confusion with the 1215 wine bar?
No, I think because my 1215 is 12 spelled out and then the number 1 and 5 like all together. And I don't remember how theirs is. But I think that's also because the Design Studio is, typically tacked on there.
Yeah. So the way that it looks or is spelled out really doesn't actually help. So what the in a lawsuit, or what even the trademark office goes off of is the way it sounds, just the way, as much as the way it looks. So a lot of entrepreneurs, a lot of startups, like they take the vowels out of things, which helps them to get the domain names and those things. And they're like, well, I'm cleaner, but it's spelled CLNR. The trademark office will treat that just the same as the fully spelled out name, and numbers, whether they're spelled out or not, will be read identically. So
And that's because it sounds the same.
correct.
Okay.
But the thing that saves you, Stephanie, is that I think those are in very different classes, right? Your
Right.
design studio versus a coffee shop is
Mhm.
kind of like Delta Airlines and Delta Faucets.
Got it.
So that's the reason I think that you're safe. So there's a bunch of factors that are considered here. I just want you to know, number one, just because somebody else, let's say somebody has, my T fit, geriatric compression socks, right? Or something like that.
That's funny.
Not gonna be a problem for you. And also, though, we could probably go after that person. So even if somebody's using the exact name as yours, and that pisses people off sometimes, especially if they have the domain and you don't, we can't go after them if the products and stuff are not confusingly similar. So just because it's the same name, it could be like the Delta Faucets, Delta Airlines situation where it's okay. Does that make sense?
Yep, that makes sense.
Okay. So here's just an example. Here's Scores Casino and Score the business organization. Should these two fight?
I don't think so.
Right. Yeah. I don't see any confusion between casino services and helping small businesses. Yep. And the marks are slightly different here, right? Not a huge difference, but Scores versus Score. They both, and the designs are different. So all those little things can add up to making it fine. Here's some other kind of quick trademarks. You guys have probably seen the knockoff Oreos with a different pattern on the front. .coms can be trademarks. And we talked about colors, but sounds can be trademarks too. So like you hear the NBC chimes from another room, and what source the program's from, right? So jingles and those kind of things can be anything that tells people, who the product originated with, can be ownable. Good?
Yep.
All right. So let's talk, and we only got a couple minutes, but let's talk about copyrights real quick. So this is probably the other bucket of relevance. So the reason I do this is so copyrights protects all these artistic creations, and then software code. I put the nerd in the basement on there. So we see a lot of copyright stuff just in the news. So music, books, art, paintings, people fighting about those things. The things for you to know, and Stephanie, for sure because you're in sort of the artistic design space, is all of these things. So photographs, videos, web content, copy, any instruction manuals you have, or course manuals, these educational submissions. All this is protected by copyright. So that's the bucket here. And a copyright, a lot like a trademark, the copyright's created the minute the work is created. So there is already a copyright in all those materials that you're using for your course. And because of that, you can and should put, again, free, the copyright symbol and the year it was created at the bottom. So just like a common law TM, that's accurate. I have entrepreneurs come up to me and they're like, I have a confession. I've been putting the copyright notice on my stuff and I've never registered anything. And I'm like, no, that's actually right. So that's correct. You know, and again, a lot of people think that you've taken these steps that you haven't, but so put that on there. The thing that's really important about that though, is that when the copyright's created, the minute the work is created, there's also a strong presumption that the author owns it. And copyrights can only be transferred in writing. And so a lot of entrepreneurs have a lot of freelancers, they have friends helping them out with things, people who are not W-2 employees. There's been some real awful lawsuits about you as the business owner may not actually own any of that content that's being created for you, even if you're paying for it. We've all heard of work made for hire. It's not nearly as strong as it sounds like it is. So if you have anybody doing any sort of content, web development, video, taking any kind of photographs, you need, independent contractor agreements with those people to make sure those rights are flowing into the business. And so T, you were kind of talking about a future license model. There's times when a company thinks they're ready and they've got a name that they can't protect or that somebody else is already using, and they come to find out that all the materials that they want to license are actually owned by a former contractor who hates them. So getting all those things like cleaned up is not difficult, but getting it all kind of buttoned up on the front end is when it's easy to get those things done. Okay. Yeah, here's just some stuff that's covered. We talked about copyright starting the minute the work is created. And here you can see, this is what a copyright, you all have seen it before, I'm sure, but you do copyright, see in a circle, the year the work was created. And if that was like a amalgamation of different dates, you can put a range there, who owns it, and then you can put all rights reserved on there. This is absolutely free, something to do, even if you've not registered anything. There are benefits to registering certain copyrights. So it's kind of like a trademark. You can go and get them registered with the Copyright Office. And if somebody knocks it off, there's a bunch of special damages and things that you can get. So if you've got if you're like, what, I'm really worried that people are going to steal this manual of how to teach a wellness class because it's so good and people are sniffing around, it might make sense to get something like that registered. And the filing fee is like $60 for copyrights. So it's not too bad.
Okay. Vance, I have to drop here.
Yep.
But I was gonna ask, will you send this out, or is there any information that we can have to reach out to you?
Yeah. So I have the most pretentious sounding name in the world. So I'm Vance Victor Van Drake III. So I'm hard to forget.
Wow.
A lot of these.
It's a lot of these. We had my son, just as an aside, like 2 years ago, and I was like, well, we got the name figured out, right? Because it's got to be the fourth. And my wife looked at me and she was like, "You are not a king." Yeah, so there's my email and my work phone. Email is easily the best. Yeah, if you want to follow up or have specific questions, just shoot me a message and I'm happy to help you out, do a little bit off the clock and make sure you're in good shape.
And do you do this filing as well? Like if we're like, hey, could you get us set up? We could come to you.
Oh yeah. Yeah, we do all the stuff. So lots of companies in town that about. Yeah, we do the branding and registrations for all of them on trademark, copyright. And I personally am a patent attorney too, so I've got a biomechanical background, but we do all the buckets.
Awesome. Well, I appreciate it.
Sure.
And I apologize for jumping on late.
No.
My dog wasn't being the best this morning.
You're totally fine. Thank you for coming. And yeah, please follow up. Let me know if I can help.
Okay, I appreciate it.
And
Sure.
I'll be sending out a copy of the recording of the webinar, so I'll make sure to include Vance's contact information there as well.
That'll be great.
Thank you.
All right. Thanks, everybody.
All right. Thanks, Vance. Have a good day.
Bye-bye.
Yeah, thank you. Bye.